Good morning. It's January 19, 2023. My name is Colleen Crouse. I'm actually speaking to you from in front of the women's tent. This is the first time I've done it. I'm going to read something without comment. The comment will come later. It is from Texas Reports, Volume 25 Supplement. Supreme Court of the United States, December term 1868. The reporter has been kindly permitted by those liberal-minded men, John Williams Wallace and his publishers, W.H. and O.H. Morrison, to publish Mr. W.'s report of the following great case, which so deeply affects the interest of Texas and the whole South that it is printed out of chronological order. It passes over mighty events which occurred between the peaceful time when the foregoing adjudications were being made and the present day. The opinion was delivered by Chief Justice Chase on the 12th of April, 1869. The synopsis was prepared by the Chief Justice himself. The State of Texas versus White and Chiles. The word state describes sometimes a people or community of individuals united more or less closely in political relations, inhabiting temporarily or permanently the same country. Often it denotes only the country or territorial region inhabited by such a community. Not unfrequently it is applied to the government under which the people live. At other times it represents the compound idea of people, territory, and government. In the Constitution, the term state most frequently expresses the combined idea just noticed of the people, territory, and government. A state, in the ordinary term of the Constitution, is a political community of free citizens, occupying a territory of defined boundaries and organized under a government sanctioned and limited by a written constitution and established by the consent of the governed. But the term is also used to express the idea of a people or political community as distinguished from the government. In this sense, it is used in the clause which provides that the United States shall guarantee to every state in the Union a republican form of government and shall protect each of them against invasion. The union of the states never was a purely artificial and arbitrary relation. It began among the colonies and grew out of common origin. Mutual sympathies, kindred principles, similar interests, and geographical relations. It was confirmed and strengthened by the necessities of war and received definite form and character and sanction from the Articles of Confederation. By these, the Union was solemnly declared to be perpetual. And when these articles were found to be inadequate to the exigencies of the country, the Constitution was ordained to form a more perfect Union. But the perpetuity and indissolubility of the Union by no means implies the loss of distinct and individual existence or of the right of self-government by the states. On the contrary, it may be not unreasonably said that the preservation of the states and the maintenance of their governments are as much within the design and care of the Constitution as the preservation of the Union and the maintenance of the national government. The Constitution, in all its provisions, looks to an indestructible union, composed of indestructible states. When Texas became one of the United States, she entered into an indissoluble relation. The union between Texas and the other states was as complete, as perpetual, and as indissoluble as the union between the original states. There was no place for reconsideration or revocation except through revolution or through consent of the states. Considered as transactions under the Constitution, the Ordinance of Secession adopted by the Convention and ratified by a majority of the citizens of Texas, and all the acts of her legislature intended to give effect to that ordinance were absolutely null. They were utterly without operation in law. The state did not cease to be a state, nor her citizens to be citizens of the Union. But in order to the exercise by a state of the right to sue in this court, there needs to be a state government competent to represent the state in its relations with the national government, so far, at least, as the institution and prosecution of a suit is concerned. While Texas was controlled by a government hostile to the United States and in affiliation with a hostile confederation, waging war upon the United States, no suit instituted in her name could be maintained in this court. It was necessary that the government and the people of the state should be restored to peaceful relations to the United States under the Constitution before such a suit could be prosecuted. Authority to suppress rebellion is found in the power to suppress insurrection and carry on war. And authority to provide for the restoration of state governments under the Constitution, when subverted and overthrown, is derived from the obligation of the United States to guarantee to every state in the Union a republican form of government. The latter, indeed, in the case of a rebellion, which involves the government of a state and for the time excludes the national authority from its limits, seems to be a necessary complement to the other. When slavery was abolished, the new freemen necessarily became part of the people, and the people still constituted the state. For states, like individuals, retain their identity, though changed to some extent in their constituent elements. And it was the state thus constituted which now entitled to the benefit of the constitutional guarantee. In the exercise of the power conferred by the guarantee clause, as in the exercise of every other constitutional power, a discretion in the choice of means is necessarily allowed. It is essential only that the means must be necessary and proper for carrying into execution the power conferred through the restoration of the state to its constitutional relations under a republican form of government, and that no acts be done and no authority exerted which is either prohibited or unsanctioned by the Constitution. So long as the war continued, it cannot be denied that the President might institute temporary government within insurgent districts occupied by the national forces, or take provisional measures in any state for the restoration of state government faithful to the Union, employing, however, in such efforts only such means and agents as were authorized by constitutional laws. But the power to carry into effect the clause of guarantee is primarily a legislative power and resides in Congress, though necessarily limited to cases where the rightful government is subverted by revolutionary violence or in imminent danger of being overthrown by an opposing government set upon force within the state. The several executives of Texas, partially at least, reorganized under the authority of the President and of Congress, having sanctioned the suit, the necessary conclusion is that it was instituted and is prosecuted by competent authority. Public property of a state alienated during rebellion by an usurping state government for the purpose of carrying on war against the United States may be reclaimed by a restored state government organized in allegiance to the Union for the benefit of the state. Exact definitions within which the acts of a state government organized in hostility to the Constitution and government of the United States must be treated as valid or invalid need not be attempted. It may be said, however, that acts necessary to peace and good order among citizens, such, for example, as acts sanctioning and protecting marriage and the domestic relations, governing the course of descent, regulating the conveyance and transfer of property, real and personal, and providing remedies for injuries to person and estate, and other similar acts, which would be valid if emanating from a lawful government, must be regarded in general as valid when proceeding from an actual, though unlawful government, and that acts in furtherance of or support of rebellion against the United States or intended to defeat the just rights of citizens and other acts of like nature must in general be regarded as invalid and void. Purchases of United States bonds issued payable to the state of Texas or bearer, alienated during rebellion by the insurgent government, and acquired after the date at which the bonds became redeemable are effected with notice of defect of title in the seller. That is the introduction to this case. The case is more than 140 pages in here. It's going to take some time to continue reviewing, but already several excerpts have made themselves of notice to me. Included in them is a description of the identification of forgery concerning these bonds, but also the role that attempting to maintain the conditions of slavery plays in charges of undermining the government and operating an unlawful government, including one that is in violation of the Constitution. It's January 19, 2023. This book was made available under what I understand to be a process wherein timelines in my own efforts came due on October 19th, 2022 and October 20th of 2022, along with a number of other books that were illegal to attempt to destroy.